Welcome, Justice Mead.
Hey, Ted.
We are on, and there's been a number of things that have happened since we were last on June 29th. One of those is our renewed civil state of emergency, effective until August 7th. And one of the other new executive orders is a strengthening of face coverings, or the face masks. It seems that if you take a look at it toward the end of the order, it looks like what they've done to strengthen, or what the governor's office has done to strengthen that authority of enforcement, is giving authority to licensing employees, state licensing employees, to enforce face coverings in establishments through the licensing and permitting process, given the authorities to municipality officers to also enforce the same, including in outdoor events where there is less than 6 feet of spacing available for gatherings, and also extending authority to enforce face covering requirements to the police. And that was effective July 8th. And Heather, did you have a recap of the visitor updates for from other states for opening up the state of Maine?
The 14-day quarantine, the Governor Mills has extended that to include, we had New Hampshire and Vermont on that originally. Now exemptions are Connecticut, New York, New Jersey. These are all exemptions from quarantine testing. Also, Mills requires that the Maine's largest retail stores, as Thad touched upon, retail stores, lodging, restaurants, outdoor bars, and tasting rooms require masks in Hancock County, Waldo, Knox, Lincoln, Saginaw, Cumberland, York, and the populous cities of the state. So, you know, the Bangor Brewers, Portland's, Auburn's. So that's something to keep in mind when you're out and about. You see a lot more masks than you did even last week already.
Thank you, Heather. And I did see a focus was even outside, if you are going to be closer than 6 feet to someone, you're expected to wear a mask. Following along with the mask requirements, Chief Mead, we are now in your part of the agenda, where my understanding is that we may have phase 3 upon us. That the judicial branch had issued a phasing process for COVID-19, and then did I see that you updated it on July 2nd?
Yes.
Justice Mead, my understanding is that you had some maybe some updates you were going to share with us about what the judicial branch is doing in the next phase.
All right, sure, I'd be happy to. Thank you, Thad, and thank you, fellow members of MSBA. It's nice to see you, at least virtually, as we are today. To give you an update, I was allegedly on vacation last week, but for a number of reasons, it didn't feel much like a vacation, but things proceed whether we go on vacation or not. Sometimes it's best to keep up with them as they're moving along, but I'll update you on what's happening and where we're headed, and if you have any questions, I would be happy to try to answer those questions. Yes, the CDC green-lighted phase 3. We are into phase 3. They were satisfied that we are ready to move forward. We have the safety measures in place. We have distancing measured out. We have face coverings. We have face shields. All court personnel now have been equipped with face shields, should they prefer to use them, and a lot of them certainly do. And we have acquired disposable face shields, plastic face shields for folks coming into the courthouse who for one reason or another would prefer not to use the cloth face coverings. We have ordered and are receiving plexiglass barriers for the courtroom to partition off the witness stand and the judge and the clerk, and even for counsel table. They are starting to arrive. We actually did make a pitch to the CDC and said, if we have these plexiglass barriers, can we do away with those annoying face coverings and face shields? And they were not quite prepared to go that far with us at this point. But I'm hoping at some point down the road that we may be able to transition to simply the barriers. But the barriers are on their way in, and we're pretty pleased about that. As you probably noticed, we changed our capacity controls in the plan to a maximum of 50 in a room, which is a quantum jump. However, that is subject to the social distancing requirements, which means that probably not many courtrooms will have 50 people shoulder to shoulder in them. We've had our court facilities folks around the state going to every courtroom, mapping them out with tape measures and markers and all the rest, and the revised capacity controls have been established statewide. We're going to try and post those on the individual courtrooms. But with our limit of 10, we had difficult situations where family members couldn't get into the courtroom during a sentencing, and the press wanted to have access, and got very complicated. So for the cases that are going to be live in person in the courtrooms, this will, I think, certainly address that and bump up the number of folks who are going to be in there. Phase 3 anticipates a green light for all case types, except for evictions, foreclosures, collections, small claims, and violations bureau. They need to wait until August, and we are working on planning that. I can talk about that in greater detail if you wish shortly. But otherwise, technically, all case types are amenable to proceeding. Two very important provisos on that. The first is we have a long-standing list of case priorities for scheduling. This has been in place a while back, and the most urgent cases, of course, get the priority in scheduling, and we will be following those priority rules as we schedule cases. And the other thing we need to be aware of is we will be issuing shortly a directive that video conferencing is the presumptive default for matters that are going to take place in the courtroom. Basically, if a case can be done by video conferencing, then it should be done, must be done by video conferencing. Well, I was hoping to have all of the video conferencing regulations and resources and rules in place already. We've been working night and day trying to get those done. We have a working group within the JB that has been working towards that. I'm hoping within the next couple of days, we will be issuing a new PMO that relates to how the video conferencing will work, the rules, the requirements, the procedures, the processes, and all the rest, to make that hopefully very clear. Zoom will be our dedicated format. We're moving to Zoom, and we have acquired like 400 licenses. And believe it or not, that was more complicated than you might think. Everything in government is always more complicated than you think. But Zoom is very specific about who must have the license and who can operate it. You don't just hand them off back and forth. I see Heather nodding. I guess you folks have been through the same thing. So we have that in place. We need to have some training for our folks to run it and host it. But we're moving along. It's processing. I'm sort of jumping around here a bit, but as you know, theoretically in September, we have said jury trials may proceed, but as with every other movement to one phase to the next, that is contingent upon being able to do it. And we have a jury working group within the judicial branch that has been working on how to do that, and it's just devilishly complicated. I think we haven't had a report yet back from this working group, but it may well be that we may need to start jury trials on a very limited basis in limited locations, kind of some trial balloons. We still have not answered some very fundamental questions, like in order to do the jury trials to keep these folks at the courthouse, CDC requirements require that the bathrooms be cleaned after every use. And in many courthouses across the state, we don't have full-time, on-duty custodians in all locations. How do we do that? We're gonna have to recruit a cadre of cleansers whose only job will be to take care of the bathrooms after juror use. So that's just one of a whole panoply of complications and challenges facing us. We are committed to getting there, but I think no one should be thinking that as of September 4th, we're going to have full docket of jury trials in every county. It's probably not going to work that way. There'll probably some trial balloons going up in the meantime. So I'm looking forward to getting those recommendations shortly. As with those decisions, everything else is based upon our commitment to the safety of the public and the profession and our own court people. Money plays into a lot of this. We are hoping to share in the CARES Act funds, which have been received but not yet allocated. We have had an enormous number of expenses that we hadn't budgeted for and were specifically created by the COVID crisis. The Zoom license is a good example. We're going to have upwards of $100,000 into licenses and audio-visual equipment, upgrades to our resources and all the rest. And obviously, we did not plan for that. So we're hoping that the state budgeting process will proceed. There will be shortfalls. And of course, we look at the specter of furloughs and temporary court closings, which we do hope we can avoid at all costs. But we, like everyone else in government, has no idea of how the budget process is going to shape up. We're looking forward to starting it. We've heard some murmurings from Augusta that they may be convening some committees to try and get back to work to look at pending legislation. And we're hoping that things will progress, but we are waiting day to day to hear about that. So as I think I mentioned at the outset, everything we're doing is affected by COVID. We are reinventing how we do it, and every solution raises 5 more questions, 5 more complications and challenges. So we are working around the clock, but we have great people working here. We have a profession that is supportive and willing to do what's needs to be done to get things back on track safely. So that's a big overview. I am agreeable to taking questions to the extent that I have the answers. But again, I welcome this opportunity to keep the lines of communication open.
Thank you, Chief Mead. I actually had been forwarded a question for you on Friday and a question for you this morning. But I'd like to just bring up the bathroom thing that you mentioned. You know, I was reading through one of the requirements for, I think it might have been barbershops opening or something like that, that mentioned a similar requirement. But I don't remember reading about who has to clean the bathroom. And I'm curious, and maybe I just missed it, but I'm curious, is it one of the things that maybe you might look into, that the person using the bathroom is the one that cleans it? And maybe that if that's allowable, that might free up some potential time of someone going into the bathroom each time someone leaves it.
It may be, you know, I mentioned that in passing. I've had some informal conversations with Justice Warren, who's sort of the chair of this working group. And I'm not 100% sure what, if anything, the requirement is for bathrooms. He just threw it out there saying, we've got 50 things we need to solve. And one is, do we need to clean the bathrooms after every use? We don't have custodians. So I'll pass along your suggestion, and maybe self-help is a way around that. But I didn't mean to suggest that I have not looked at the requirements myself, but I just wanted to say that there are a number of questions floating out there. Hopefully that's not a deal killer. I mean, hopefully that's something we can work around between human ingenuity. We can get around that one. That the capacity controls and the space and the voir dire and people seeking exemptions because of health concerns, much more complicated. We'll solve the bathroom thing one way or the other.
Roger that. And along with other things that you're juggling for moving parts, there's also still the rollout of electronic filing, right?
Yes.
And do you know, do we have a final set of main rules of electronic court systems?
You do not, but my colleagues and I are going to be talking about that on Thursday.
Okay. And I know that the MSBA is working on rolling out training, working through your communications department, and we're looking at starting that process the end of August for your planned, I think it's October 6th or 5th rollout. 5th, okay, I'm told by Heather, October 5th rollout of the electronic filing system in Bangor area, or District 5, I think it's called, right?
Yes.
So
Yeah, that's the Region 5 rollout. It is still on schedule. I have told our IT folks, if we are behind the 8 ball, that there's no reason why we can't kick it down the road, but they are a very dedicated group, very capable group. And they say it's still on. It would be rolled out in Region 5, which is basically Bangor and some surrounding areas, but basically Bangor, and will not be on all case types. There will be a limited number of case types. And there will be training for lawyers, for office administrative assistants. When we did our initial look-see the last time around, I wrote a personal letter to every lawyer in Region 5 and said, you're welcome to come down, you're welcome to bring your administrative staff down. And I would say the turnout for that session was probably maybe 20% lawyers, and the other 80% was the staff professionals, the people who, do the actual, on the ground work and getting things filed and stuff and the rest of it. So we will make sure that lawyers and their administrative staff will have the questions answered. And I think if anyone is apprehensive about it, I think once you get in the nuts of the bolts of the thing, which I have seen, I'm quite involved with it. It's really quite intuitive, and it really works itself through. And I think once people get over that initial apprehension bump, I think it'll be well received. But it's definitely going to be a pilot program. This is the shakedown cruise. And if we discover deficits in training or functionality, we'll be fixing it before it rolls out in any other county. The tricky aspect of a incremental rollout is that there will be provisions in the electronic rules that have implications for other court rules, the civil rules, criminal rules, family rules. So in those cases, the court rules will have to be modified to be consistent. And we are looking at how to do that. I mean, if we only roll it out for limited case types in Region 5, how do we reconcile that? It may well be that we'll come up with a solution that says in any region in which the CMS and e-filing is rolled out, then the rules, it's called the Rex rules, would preempt any court rules, and then we would change the court rules when all regions are on board. But this is one of many questions we need to solve before we hit the go button.
Oh, thank you, Chief Mead. Now, now the 2 questions that were given to us. So you just announced that you bought all these licenses for Zoom, and you're ready to start rolling into Zoom as a video platform. You had mentioned that there were some shortcomings with, I think, Google Meets that you didn't like, so that's why you're rolling into Zoom. Now, there was a constituent down in York County that mentioned that what he likes about Google Meets is that there is a closed caption feature on it. And he was saying with the, meaning that you can opt for that feature and it will actually start, printing voice across the screen. I have not used that feature, but he mentioned that he has used it and his clients have used it. And then he's concerned that Zoom might not have that. And I don't know.
That's a question I'll have to pass on to our IT folks. When they looked at all of the existing platforms out there, the Microsoft Teams and all the rest.
Zoom has that feature as well.
Okay.
Costs more money, of course.
Okay.
So that's good to know. I wasn't aware of the issue or the question, but and thank you. If it does have that feature, we will look into acquiring it, but I will pass it on to the IT folks. And thank you for the information.
Okay, and thank you. And then the other question that came in this morning was, so you list those exceptions for the cases that are not going to be heard in phase 3. So when you talk about FEDs in phase 3, in parentheses, I think you mentioned evictions.
Yes.
Now, there's a special FED process for personal property.
Okay.
And
All right.
is that something that you envision the
22nd.
court permitting in phase 3?
That is a good question. I will need to go back and look at our notes on when we promulgated those limited case types. My recollection was that that focused on residential issues for a couple of reasons, not the least of which that it's typically a large docket. I'm not sure how large the dockets are for FED of personal property, and if they aren't large, then that factor would not be relevant there, and it certainly doesn't involve loss of residence, I believe. So that factor wouldn't be present. So I'll take that back to the court and ask them about that. I don't.
And that's the thing. It was a constituent that just asked for that point of clarification because there was instead of just saying FEDs, I had it pulled up here. I was just trying to pull it up again. Right next to the FED, it does say in parentheses just eviction and landlord tenant. So that would be great to hear back on that. And
Excuse
then-
me.
yes.
Hi, it's Nancy Schiff Slater from Pine Tree. Mobile homes sometimes they do fall under personal property FEDs.
Huh.
So
Yeah,
in
okay.
terms of residence, it would implicate that, definitely.
It's good to know.
Yeah, that's a good point, Nancy. What I had been thinking of was in this
Deals?
person's question was chattels, that.
Yeah.
Yeah.
And also cars.
Right.
Yep. I will look into that and see if I can get some insight as to what the intended scope was there.
Thank you.
Thank you.
And are there any other questions? I had a couple more here, but if there are some that someone wants to voice.
I can talk a little bit about, the evictions is a big topic for everybody concerned about this. And the fact that the doors open in August, there still are some nuances we need to be aware of. The Federal CARES Act has its own prohibitions on evictions for any property that has some sort of federal connection, federally financed. There's a list of matters there. And the CARES Act prohibitions would run it actually through August. So obviously we can't proceed with any of those that fall into that category. So we are in the process right now of putting together an affidavit that a landlord must file to allow us to identify whether or not these involve federal financing and would be subject and superseded by the CARES Act prohibitions. So those matters, if someone has a federally financed housing project and they want to get back in for evictions in August, the federal act will continue to stay that through the month of August. We need to know it. And if it is not a matter that is stayed, we will probably schedule based upon, there were a number of eviction cases that had been previously, notices were filed, complaints were filed, scheduled for hearing, and ended up being continued. We'll probably schedule those first. There are quite a number, and our people are actually going to look into the backlogged cases, inquire into them one by one, and see if any of them are amenable to resolution by agreement. If the parties have hammered out an agreement, talk to the attorneys on both sides. And if it is a matter that can be taken by agreement, we'll move those up to the front and get those done. If it is a matter that is awaiting a contested hearing, then it will be scheduled based upon the timing and the age of it. So it's not a simple matter of pushing buttons saying we're going to hear lots of evictions. Our trial court chiefs are working very hard on determining how this is going to move forward, and we want to do it in a very organized, not willy-nilly kind of a way. And Pine Tree actually has been very helpful with the doors to the community lines of communication, but open with Pine Tree and with the landlords' representatives. we all want to do this in an organized and appropriate fashion.
We appreciate it very much.
Chief Mead, one of the things that you've already kind of alluded to is essentially the rollout into phase 4, which, and by the way, phase 3, just for codification, when did you roll it out, or is it rolling out today? I noticed the target was, I think, July 6th, right?
Yes, that we have not issued a PMO amending that, so that happened by virtue of the timing. The process is we went to CDC in advance of the 6th and said, here's what we have in place. You, meaning the CDC, will look at the COVID circumstances out there, the numbers, and are we okay to go ahead with our plan on the 6th, assuming we have these numbers? And they got back and said, yes, you have complied with all those requirements. You still need to use the face shields in the courtroom, even with the barriers. We'll see if that changes down the road. So that that plan, I should have said, the plan is still in effect. So phase 3 is here, and the parties are working very hard at scheduling priority cases, doing them by remote conferencing if it is available, or in courtroom if not. It's we're taking baby steps right now. Phase 3 really is the launch pad for phase 4. If we get to the end of phase 3 and things are not organized, not moving smoothly, we may need to take a look at it. But I'm really optimistic that with everyone's cooperation, we'll have our remote video stuff up and running. We'll have all our courtroom security and face mask and distancing requirements in place, and that phase 4 will be an easy step forward. Well, not easy, but it'll be an appropriate step forward at the time.
And given that thought, Chief Mead, we're looking at probably about 3 weeks, I think, out from here before phase 4 is scheduled to start. Are the courts issuing notices at all for the backlog that you had mentioned that's there, that has probably been accumulating since March, of these cases that have been exempted out of phase 3 in going into phase 4? Are they going to start sending notices now for hearing dates that are after August 3rd, or are we not sending notices out yet?
My understanding is that they're moving forward with it. If we saw clouds on the horizon about phase 4, like the eviction situation, we need to get those arrangements set up before any notices go out. But if there are other matters on that priority list that would be appropriate, they could. The trial court chiefs and the regional judges are working on that, but I believe notices certainly for phase 3 are going out, and as phase 4 looms, I'm sure they will also, assuming that we're confident that we're going to be able to proceed.
Thank you, Chief. Are there any other questions for Chief Mead while he's offered to take them? And then we'll give.
I have one.
Go ahead.
Sorry, it's Nancy again from Shift Slater. So when you talk about the rooms having a capacity of 50 people, this may be a silly question, but does that include everybody, including the judge and the recorder and the bailiffs, or is that litigants?
We asked about that, and that is if you're a living, breathing human being with a beating heart, you're one of the 50.
Okay, thank you.
The breathing part's the important part there, because that's
absolutely. Thank you.
And Your Honor, we'll give the customary, I'm told it's customary to allow 10 seconds in Zoom for persons to be able to access their mute button or do whatever they need to do to ask the question. And while we're waiting to see if there are any other questions, I did want to invite you to continue on with us. We have about 1 more minute of sharing our business side, and then closing down for the day.
I don't have any particular comments to make, except that working very, very hard. I take my hat off to the chiefs and the RJs and the clerks and everybody who is taking all this time. I actually sent a letter recently to the marshals. I don't know if it surprises anyone, but COVID is kind of making everybody a little edgy, a little ornery. And folks coming to the courthouse are kind of ramped up and amped up, maybe a bit more than normal. But our marshals are doing a fabulous job of de-escalating and explaining to them it's about safety. So I'll take a chance to say thank you again to the marshals. And if you should interact with one of our marshals, please thank them for the great job they're doing.
Chief, there was, thank you. There was a question that came from Attorney Montgomery asking about mediations. I'm assuming that he's referring to like family mediations. But are those in full swing to happen remotely now?
It's my understanding that they are happening. I've heard from our mediation folks that it's going well. We've also had some feedback from the mediation folks that a lot of the parties are liking it, that they feel that it is a better setting, more productive, as opposed to having two people in a highly emotionally charged situation forced into a tiny little room sitting across from each other, that it can be dealt with much more efficiently and civilly through the remote proceedings. So we'll see how that goes. The other footnote to this is, I think mediation really lends itself to the remote video process. We're still experimenting with it, and any mediators out there, I would welcome any feedback from them on how they think it's going. That's not something I'm typically tapped into. So I would love to hear from folks on the ground who are doing mediations if they think it's a good, a bad, or a neutral way of conducting mediations.
Yeah, and Chief, we can forward to you any of that feedback for you that we receive. We'll get it forwarded to the judicial branch.
That'd be great.
And unfortunately, we've got to wrap up. I appreciate your giving us some insights into Phase 3, Your Honor, and attending with us today. And I appreciate everyone's attendance here. Know that we do have a diversity committee that is working hard. It's met a few times, and they're creating some good road mapping and planning.
Great.
We're excited about that.
Excellent.
All right.
All right. Well, I'll sign off and take my leave. Thank all of you for your time and this opportunity to communicate, and stay well, and we'll keep fighting the good fight. See ya. Bye-bye.
Thank you, Your Honor. All right, everyone. Thank you very much. And any questions, forward them up our way, and we'll share them. And we'll also share the answers. Thank you, Heather.